The number one piece of advice I have about the new USCIS memo relating to green cards is that anybody who's applying for a green card through an adjustment of status, if you're submitting your application or you have an interview coming up, start to think about your discretionary packet. So you're going to want to start including before your interview basically an affidavit and some evidence about why you warrant a favorable exercise of discretion. Because essentially this memo says eligibility for adjustment isn't enough anymore. We also want you to show us that you warrant a favorable exercise of discretion. So that means touching on how you entered the country, why you overstayed your visa if you did, why you can't go back to your country, what your family ties are in this country. Are you married? Do you have kids? Do you have a job? Do you own a home? Do you pay taxes? Do you take care of elderly in-laws? What is the story of you and your family and your good moral character? And why should this officer, who's going to be the decision maker in your case, decide that you should get a green card without having to leave the country? This is what they're going to start expecting at interviews for green cards in light of the new memo. Ultimately, I don't think this memo will survive litigation. I think that this policy will go away and all of this is temporary. That's my analysis and my hope as an immigration lawyer. In the meantime, what we need to be doing is submitting evidence about favorable discretion. That is definitely something that your lawyer can and should do for you, and is my number one recommendation as a way to respond to this new memo. What you don't want to do is decide to leave the country, decide you don't qualify anymore, don't apply, put your case on hold, any of that stuff until you talk to a lawyer. But those are not going to really be recommended actions by any lawyer who's paying attention, in my opinion.